What if, back when you bought a home or your parents bought their home, the real estate lawyer who closed the deal and registered title in land registry made a mistake and did it wrong? Would you ever think to check something like this? Hi, I'm Michael Shuster, award-winning real estate specialist in the Greater Toronto Area and the suburbs. I recently sold a property for a client. My client has power of attorney for her elderly mother, while her dad passed away years ago. When I listed the property for sale, part of my due diligence was to check land registry to make sure that the names on my contract for listing it match the names that the property is registered to. When two spouses are on title, 99.9% of the time, they're registered as what's called joint tenants with right of survivorship. So, if one spouse dies, then the half of the property that belongs to the deceased spouse automatically reverts to the surviving spouse. When I checked title for my listing, it had two names on title, but the husband passed away years ago. This actually isn't uncommon. Often, when a spouse dies, the surviving spouse will have a lawyer update land registry just to the sole name of the surviving spouse. It's almost just as common, though, that I sell homes and they didn't remove the deceased spouse's name from title. As lawyers have confirmed for me many times, due to right of survivorship, the surviving spouse owns the home and therefore is the seller. So I went ahead and listed and sold this property just like many others. And 1 week before the sale was scheduled to close or be completed, my client got a phone call from the real estate lawyer. Turns out, when her parents bought the place many years ago, the lawyer who did the purchase for them did not register ownership with land registry properly. He registered ownership as tenants in common, not joint tenants with right of survivorship. Now, tenants in common is a rare option for scenarios such as two investors or multiple investors who might buy an investment property together. That way, if one partner dies unexpectedly, each partner can leave their half or portion to their beneficiaries in their will. The heirs effectively become partners with the other tenant or tenants in common. But in the case of two spouses, when one spouse is no longer alive and they didn't probate his will because he had no other money or assets, that half of the property doesn't automatically revert to the surviving spouse. That half isn't effectively owned yet by anybody and therefore can't be sold. I mean, we could sell half the property legally, but who wants to buy half a property? Obviously, there are ways to deal with the current situation, but they are complicated and they take a lot of time, sometimes up to a year, which means the buyers are now stuck in limbo, might sue the sellers, and the sellers are stuck with carrying costs for up to a year. Now, there are ways to double check this. It's also very important for you to know when you prepare your will. Do you want to know more about this topic and how to protect yourself and or your family? Just email me, mike@moveinontario.ca, or call me anytime. I'm happy to answer your questions and share everything I've learned about this topic. Thanks for watching.